Good afternoon, everyone. Got it on the first try. I like that. So as I think all of you know, I'm Horace Anderson. I'm the dean here at the Elisabeth Haub School of Law at Pace University. And I am really thrilled that you are joining us here for the 2025 Blaine Sloan Lecture. I cannot explain to you how excited I am to welcome a friend, a colleague, and a renowned expert in international intellectual property law. And what was my field again before I became your dean? Thank you. Ruth Okediji is, like I said, a friend, a leader in the field, and I'm so happy to have her here to deliver this year's lecture. She is the Jeremiah Smith Jr. Professor of Law at Harvard Law School and the co-director of Harvard University's Berkman Klein Center for Internet and Society. Her lecture today is titled Progress and Progressive Intellectual Property Treaties, New Issues, New Actors. And see if there's anybody who's been in any of my IP classes still left here. But those of you who have studied IP know that the intellectual property clause of the US Constitution gives Congress the power to create and regulate patents and copyrights. And that system, that framework is increasingly having to connect with, commune with, an evolving international IP order that goes way beyond what I'm guessing what the framers envisioned when they drafted the intellectual property clause. Some of the most important developments in intellectual property law in the 21st century are coming from the international treaty-making processes that are attempting to include diverse interests, diverse voices, diverse peoples and communities in the global innovation system. And I'm really excited, just as a member of the audience, to hear what Professor Okediji has to say on those matters. The Blaine Sloan Lecture on International Law has been an annual tradition at Haub Law since it was first established in 1988, the lecture, that is. It was created in honor of F. Blaine Sloan, who was instrumental in developing the International Law Studies program at Pace Law School. A member of the UN Legal Office for 3 decades and director of the General Legal Division, Professor Sloan contributed significantly to the advancement of private and public international law, representing the UN at key negotiations on trade, maritime law, and outer space. He was a respected legal advisor on international warfare, peacekeeping, and refugee relief in the Middle East and Asia, and on Security Council matters in Africa and Latin America. Today, Professor Okediji is joining a long list of distinguished Blaine Sloan lecturers who we've been privileged to welcome for the past 37 years. Some of the recent notable lecturers include Professor Margaret M. de Guzman, co-director of the Institute for International Law and Public Policy at Temple Law School, Jorge Islas Lopez, Consul General of Mexico in New York, Professor Sarah Cleveland, Louis Henkin Professor of Human and Constitutional Rights at Columbia Law School, and Dr. Boris Kosolchik, President and Executive Director of the National Law Center for Inter-American Free Trade. Professor Okediji, welcome, and we and I look forward to learning from you today. Now to officially introduce Professor Okediji, I'd like to invite to the podium Professor Smita Narula, the Haub Distinguished Professor of International Law and co-director of the Global Center for Environmental Legal Studies.
Good afternoon, everyone. Good afternoon. It is a privilege and indeed a personal and intellectual thrill for me to introduce today's distinguished speaker, a scholar whose work has reshaped the way that we think about law, innovation, and global justice. A prolific scholar, Professor Okediji is a driving force in reimagining international IP law, not as a rigid system of control, but as a tool for inclusion, creativity, and global development. Her widely cited scholarship appears in leading law journals around the world, and she has edited and authored leading books in this field, including Copyright Law in an Age of Limitations and Exceptions, and International Patent Law and Policy, a foundational text on the global patent system. Professor Okediji's scholarship spans multiple legal disciplines, contributing to works such as the Oxford Handbook of Christianity and Law and the Research Handbook on Intellectual Property and Investment Law. She's been a powerful voice in critiquing IP law's failure to protect traditional knowledge, framing its stewardship as both a legal and moral responsibility, and advocating for policies that respect Indigenous governance. Her work has influenced policies across sub-Saharan Africa, the Caribbean, and Latin America, and her expertise has been sought by the UN, the World Trade Organization, the World Intellectual Property Organization, where she has helped to ensure that IP law serves as a force for inclusion rather than exclusion. As Nigeria's chief technical expert and lead negotiator at the 2013 WIPO Diplomatic Conference, for example, she helped shape the Marrakesh Treaty, which expands access to published works for people with disabilities. She has also been appointed to the UN High-Level Panel on Access to Medicine, addressing critical global challenges in health and technology. Professor Okediji's groundbreaking contributions have earned her numerous accolades, including the 2023 Barry Prize for Distinguished Intellectual Achievement, as well as election to the American Law Institute. But beyond her scholarly influence, and what will be of great interest to the many students in the room today, is the fact that Professor Okediji is celebrated for her unwavering commitment to teaching and to mentorship. In a 2023 conversation about her journey to becoming a law professor, she recalled stepping into her first classroom to teach intellectual property. Unknown to me, and despite much trepidation, she said, I stepped into my destiny. The only way to describe it is that I came alive in a way I cannot fully express. Everything about me, heart, mind, and spirit, felt fully engaged and energized. I deeply wanted my students to appreciate the power and role of law in shaping human flourishing. From that day on, I was gone. It was like falling in love at first sight and never looking back. I knew then that law teaching was my calling. Well, I know I'll be bringing some of that energy to our property law class this afternoon, or at least I hope to do so. So it will come as no surprise that Professor Okediji has received multiple awards for excellence in teaching and in mentoring. In her last lecture to Harvard Law's class of 2020, she urged graduates to cultivate the courage to try something new. It is advice she has embodied throughout her career, fearlessly confronting difficult questions and reimagining the law in ways that serve the broader public good. And today we have the great privilege of hearing from her as she delivers the 2025 Blaine Sloan Lecture on International Law as we navigate a rapidly evolving world where digital technologies challenge traditional legal frameworks and global inequalities demand new solutions. There is no one better equipped to guide us through these pressing issues. Please join me in welcoming her today.
I gotta give you a hug for that. Thank you so much. That was quite an introduction, and I would just move upstate New York just to get that every day. So thank you so much. I understand that I only have 35 minutes to deliver this lecture, and I am happy for you, but sad for me for that time limit. I'm just returning from Geneva, where we've been negotiating a treaty for the last 20 plus years. It is the last sliver of a set of treaties that were demanded by countries from the global South. And so today my lecture is really going to focus, and especially for you students who are really interested in intellectual property, interested in international law, and in careers in international law, I want to give you both the things that are hopeful and the things that cause me some trepidation. I first learned intellectual property actually as an undergraduate student. I was needing to write a paper on for my honors a thesis, and a professor who was a mentor of mine said, well, you know, I just came back from a conference. Why don't you go read the papers that were submitted at that conference, and then see if there's anything there that you're interested in. And that just changed my career trajectory. It changed my law school focus. The set of papers were on the transfer of technology and the patent system. And my parents, to this day, scratch their heads when I said I'm interested in patents and tech transfer. Now, you have to remember that this was, you know, a good almost 40 years ago. And so this was pre-iPhone, pre-email, pre-everything. And the idea that we would be living in such a moment is one that I think neither my parents nor myself could anticipate. So I want to say at the outset, before I launch formally into the lecture to you law students, that you may be interested in something that is arcane. It may be a sliver of something in property law, rule against perpetuities, God forbid, but if that were it, right? It could be something highly hyper-technical about cybersecurity, or some historical approach to tax. Whatever it is, it may seem arcane and unimportant, and certainly not the cutting edge of what your colleagues are studying. But if it is your passion, I encourage you to stick with it. Figure out ways to build a garden around it. Do other things in law that that you enjoy, but don't lose sight of your passion. Because for about a decade and a half, I worked in intellectual property. And I remember people would ask me, well, what area of law are you interested in? And I'd say intellectual property. And the first question would be, well, what's that? And now I get into a cab in New York City. I'm coming up to White Plains, and the cab driver says, well, what do you do? And I said, well, I'm an IP professor. Intellectual property? Can I ask you about my brother who writes a piece of music? And you know, off we go, right? Off we go. And everyone knows about the tech economy and about intellectual property and creativity and innovation. That was not the case when I began. And I had to learn to stay the course. I had to learn to figure out ways to make sure that I kept on top of a field that most law schools were not teaching. Your dean and I and many of us in this room did not go to law school where IP was on the curriculum. It was actually reserved for night classes, for engineers who wanted to be patent agents. And today it is one of the leading areas of law, one of the areas of almost guaranteed employment, and of course, driving the engine of our knowledge economy. But it took decades to get there. So I want to encourage you to stay the course. Okay, now to my lecture. So I want to speak to you today about progress and progressive IP treaties. And as I said, I am just returning. Let's see if the technology, I'm not sure, it's not turning for me, so did it turn? There we go. Every student in their first day of class in intellectual property will be introduced to what we now refer to as the IP clause of the US Constitution. In that clause, Congress is empowered to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. If you look at this clause, some have referred to it as the Progress Clause, others have referred to it as the Copyright and Patent Clause. It's referred to, I think, somewhat erroneously as the IP Clause because trademarks are not actually captured in this power of Congress. But it is essentially deferring to Congress the authority to promote innovation and creativity. It has some caveats, which we will not get into this afternoon, but it is to promote the progress of science and the useful arts by giving authors and inventors exclusive rights, which we now know to be copyright and patents, and then the trademarks, sort of attention to trademarks is covered by the Commerce Clause. But I want you to note their respective writings and discoveries. This is 1789. If you were to pull up the economic landscape of the population in the United States at that time, many, upwards of about 60 to 70% of the population did not read or write. This was a time when women could not own property, when slaves could not own or be recognized to own property, much less be fully human, and when Indian tribes were still, of course, struggling for their sovereignty. So I want to talk to you this afternoon about this idea of progress, and particularly progress through innovation. First, as every IP student in the audience knows, not every innovation is captured by the intellectual property clause. The statutes that are built on this provision have qualifications for what counts as a patent, what counts as a trademark, and what counts as a copyright. So there's much innovation that occurs outside of the formal intellectual property system, but the bulk of marketable innovation flows from this IP clause. And by its very definition, the IP clause restricts Congress's promotion of innovation to writings and discoveries. That, of course, has implications for a non-literary culture. It has implications for oral cultures, which constitute the vast majority of the global South. So when you think about US IP law, the centralization of intellectual property protection really began to drive the engine of industrialization in the United States. The patent statutes, the copyright statutes really took off. Prior to the federal system of intellectual property, there were states that protected copyright, some states that really attempted to protect patent law. And there were no formal patent laws in this early colonial period. And so we began to see in the late 1800s, late 18th century, South Carolina was really the first to try to pass a state patent law until it became clear as an early and young country that if we were going to have industrialization be the bedrock of a flourishing economy, that the federal government had to provide some policy and regulatory and legal institutions to promote innovation. And so in 1787, we got the Constitution, and in 1790, we got the first Federal Copyright Act and the first Federal Patent Act. This history is important because there are 2 points that the US is quick to make on the international plane. The first is that the defense of intellectual property is central to what we think about America. That we would not be a nation as powerful and as influential internationally, but for the technologies that we are able to supply and provide to the rest of the world. That includes nuclear technology, military technology, but all forms of technology. Second, the US makes clear on the international scale that for as long as our history has been tied to our technological superiority, the rules that govern technology must be rules that make sense within the ecosystem of the American legal structures. And so, for example, go back to the IP clause, writings become really central in our intellectual property system. In order for you to obtain a copyright, it must be written. This lecture that I am giving this afternoon is not copyright eligible unless it's fixed in a tangible medium of expression, unless I had written it out, was reading it out to you. Now there's probably some simultaneous recording going on and we can talk about that, but the foundational expectation is that innovation must be discernible in a culture that is literary. And so IP law has been really built on this. And when you look at this act, it is an act to promote the encouragement of learning. So learning teaching, and access to the learned mind has been core, certainly in the copyright space and even as well in the patent space. This is important because if you look at the histories of copyright, certainly in the United States, you can see that dating back to this late 18th century period, many states in the Northeast had already begun to pass copyright laws at the state level. And if you look at those laws, they always began with the following words: an act to encourage learning. Or you would see in the preamble the word education. In other words, the founders were very clear, and the leaders of the early states were very clear that in the absence of an educated populace, that the country could not advance. So intellectual property and the advancement of the national economy became intertwined. This did not change once we adopted the federal copyright system and the federal patent system. Now, a couple of points. If you look at the states on the slide in front of you, many of these states were slave-owning states. Many of these states had reservations. But many of these states were also actually states that were very active in the revolution, very active in supporting freedom, very active in the progressive sense of advancing the cause of equality among all Americans. I think this is an important slide for you students to see because many of the laws and many of the regimes that we think of as progressive, many of the causes that we think of as progressive, fundamentally can be oriented in ways that are anti-progressive. So here you had states that were very well known for their work in supporting abolitionists, for their work in encouraging freedom for enslaved persons, but yet the laws that were set in place, that were specifically designed to advance this notion of what we mean as a country that was part of an international system, was very much a law that was conditioned on access to education and access to other public goods that many, many Americans simply did not have. At the same time as this was unfolding in the United States, internationally, there was a crisis. Of course, America, having become independent, was very much watching to see what alliances it would build globally. In 1883, the first international patents treaty was entered into, called the Paris Convention for the Protection of Industrial Property. This 1883 treaty remains a bedrock of international patent law today, but it's an important treaty because the reason it came about was European countries unwilling to show, unwilling to demonstrate their various innovations for fear that other countries would steal them, for fear that there would be free riding. And so the Congress in Vienna really began as a way of encouraging international protection for IP. And so the Paris Convention for 1883 became the first international treaty. It covered trademarks as well and unfair competition. It was very quickly followed by the Berne Convention of 1886, which protected literary works. Now, what was happening? Many, many famous European authors would travel to the US and discover their literary works being sold, being copied, being distributed for pennies, literally. And authors, famous authors, began to complain about the plight of authors in Europe whose works were being copied for free in the United States. And so the push, very similar to the Patent Convention, the push for an international copyright treaty began as a fundamental right of authors. Authorship in this regard was not just the ability to write, but the ability to earn an income from your writing. And so Charles Dickens, very famously, Victor Hugo, very famously, began to push for an international system to protect the written works of authors. Now, what was happening? So this is 1883, 1886. What was happening in much of the global South? And I'm picking on sub-Saharan Africa, Africa as a continent here. Of course, the famous Berlin Conference occurred in 1885, the division of Africa amongst European powers. And so at the time that the foundations of the international intellectual property system was being laid was also the grand colonial experiment. So here we already had a system that actually excluded a great majority of Americans because they didn't write, they weren't literary, because they were enslaved persons, because they were Indians. And simultaneously, we were carving up Africa amongst the Europeans. And so you see the coalescing of these great historical moments in which law was being passed, laws that remain vital and really relevant today, but were being established and constructed around identities, around cultural preferences, and around historical experiences that really isolated a minority and built the laws around that minority experience. And so Africa was being divided between Europe, between German and Spanish and French and English European powers. This is, of course, a map of contemporary Africa. But for IP purposes, this is the map that really matters. Till this day, as we negotiate international IP treaties, the fault lines occur around who was the colonial administrator. This is striking. Why? Because the common law system and the European continental law systems did not approach intellectual property the same way. So, for example, because in the common law system, the public domain is such a critical part of intellectual property's progressive move, we want a rich and vibrant public domain because of the First Amendment. We want a rich and private public domain because nobody creates anything out of nothing. Everyone's works builds on the existing ecosystem of literary and creative works. And so we have the public domain because we recognize also that copyright is not a natural right. We view copyright simply as a monopoly that's necessary to incentivize the kind of creativity at optimal levels that we want as a nation. So fundamentally, the common law approach to copyright looks very different from the French and German continental approach that views authorship as a fundamental human right, and that therefore expands and extends copyright protection over things such as moral rights, for example, the right to be known as the author, the right for the work not to be messed with. So painting a mustache on the Mona Lisa would be a violation in Europe in a way that it would not be in the United States because of the First Amendment. So you see that the philosophical approach of Europe's powers fundamentally shaped the way those powers viewed intellectual property. And those fundamental philosophies have mapped onto the former colonies. So that today, when you're negotiating an intellectual property treaty of the United Nations, it matters whether you were colonized by France or whether you were colonized by the UK. This has mammoth ramifications. And because I'm being recorded, I can't share as frankly as I would, but trust me when I say that British Africa and French Africa do not think the same way. And the fact that you even refer to former British colonies and former French colonies differently, and that there is no such thing as an African approach to intellectual property, fundamentally because of the colonial enterprise. Now, one example that's quite interesting, and I'm going to give you two examples because I think as law students who will be future judges, who will be future lawyers and scholars, it's important for you to think about legislative design. The British never once said that locals, citizens of colonies, could not own a copyright. Now, in the United States, enslaved persons were not allowed in many places to read or write, and they could not own copyrights, and they could not file for patents. That was the law in the United States. And so many enslaved inventors, many enslaved writers could never own the literary works, literary rights to their works. The British in West Africa, in Jamaica, in India, never said that. But here's what the law did require. If you were going to write a novel or do anything written that would qualify for copyright under British copyright law, you had to go to England to get it registered. Now, if you are a citizen in a colonial, community, entity, quasi-sovereign, where and how would you get to London to register your copyright? So de facto, many authors in these colonies simply could not benefit from the colonial copyright system, and the British left it up to the colonial governors to decide whether or not there would be colonial IP laws. So for example, in India, an area where I'm working on now, the Indian colonial administrator decided that there would be an Indian patent law. And if you go to the records in the British Library, where I've spent now lots and lots of time, you can see patents granted to Indians dating way back to the early 18th century because the colonial administrator said it was okay to do so in India. Contrast that with Jamaica, another British colony. The colonial administrator in Jamaica said, nah, I really don't want the natives thinking they can invent anything. Let them pick sugar cane, let's get this sugar out. That's what I want to focus on. And the project actually that I'm working on now is tracing how the technological development of former colonies really evolved consistent with this single decision technologically as to whether or not natives could file for a patent or file for a copyright, and whether or not they could in fact get those registered and protected. All right, but I digress. So today, fast forward to 2024, 2025, we still see these fractures operating in the UN system. Another example that I will give you. In the British former colonies, you are entitled to file or to obtain copyright in your performances, but they had to be performances that didn't undermine the crown. So where First Amendment privileges would have kicked in as a colonial territory, there were no such protections. And so even if you created, there was a vetting process in which the crown had to approve of what you had invented and what you had written or performed. And so on and on I could go on, but you get the point that the legal framework for intellectual property in these societies did not facilitate participation, nor did it facilitate any benefit. In the 1960s, as the colonial project began to fall apart, converging very much with the advancement of the civil rights movement in the United States, we saw many countries become independent in the 1960s through the early 1970s, throughout the global South. That independence, one would have thought, would have produced a level of sovereignty over intellectual property policy. That did not happen because of how built in and how entrenched the intellectual property system had become. And so I don't have the time to get into it, but as a matter of international law, with one signature The 1883 Paris Convention and the 1886 Berne Convention became binding on about 89% of the global South. So once the British government signed the Berne Convention and signed the Paris Convention, all British colonies were essentially covered by these international treaties. So once independence came, there was a legal crisis. What do we do? These colonies were bound by these international treaties, and now they're independent. Like, how do we assimilate over 100 countries overnight into the intellectual property system? The answer was a fine legal tool, which was to essentially say to the former colonies, unless you opt out of the treaties, you will remain bound by them. Now, I want you to think about the state of these former colonies in the 1960s. Barely literate, organized only around the British economy, with little attention to local innovation and local creativity. So what we had were countries that were independent, but in fact, the laws that governed them were still the laws that had been in place under the colonial arrangement. So by the time we got the TRIPS agreement in 1994, I remember traveling to South Africa, being asked to help modify the South African IP laws. And I was going around all of Africa, and there were still imperial stamps on the statutes. Like, they hadn't even bothered to remove Great Britain from the statutes. They were still there in 1994. And so the TRIPS agreement came around, and the TRIPS agreement did something that the Paris Convention and the Berne Convention did not do. The TRIPS agreement made it mandatory, in order to participate in the international economic system, you had to conform your national laws to the laws that existed that were essentially US and European. And so in order to accommodate these developing countries, TRIPS Article 7 basically said, okay, we recognize that there are countries who really are technologically lacking. They're technologically behind. And as a result, we have TRIPS Article 7. But many of you who are students of international law and who understand the power of the Vienna Convention and the interpretation of international law understand that this particular sort of provision is aspirational. There is nothing within TRIPS Article 7 which says that the protection of IP must benefit users as well as owners. It must be conducive to social and economic welfare and to a balance of rights and obligations. How exactly do poor countries get to benefit from this system? Now, the answer was they don't. They're by and large trapped in a system in which they must uphold tenets of IP that have been part and parcel of their heritage for many years. And I really said this, believe it or not, I was Ruth Ghana at one point. I am now Ruth Okediji. But in an early article, I made the claim that the chief aim of the TRIPS agreement is to secure from these developing countries and societies the full monopoly benefits that Western intellectual property laws offer. And of course, once this TRIPS agreement kicked into place, there was no longer any opportunity for flexibility, for reorienting the system to benefit the local economy. And so what does that mean for the United States, which is called constitutionally to promote the progress of science and the useful arts? I think the first thing you want to learn is that this idea of progress remains a narrow conception. It is still a conception tied to a literary society in which innovation occurs in very specific ways. When you look at this idea of innovation, I want you to consider, for example, I have on the slide the use of fire to control burns by indigenous populations in both North America and in Australia. When the British began to control indigenous populations in Australia, they banned burning, banned it. Why? Because the British at the time wanted to make sure that the agricultural system was what prevailed. And so indigenous innovation was completely stamped out. Today, these same ideas about controlling burning are being introduced again into the Australian economy. And so what has happened, of course, is that we have now made international these rights, these criteria: fixation, originality and novelty, limited duration, individual ownership. These are all intellectual property norms that are completely inconsistent with collective and communitarian approaches to life, which is what you find in virtually most of the major economies of the global South. And so there has now been a push to reorient intellectual property at the international level to begin to accommodate communal, communitarian, social justice, in quotes, more principles in order to do this. This has come about principally by the move to protect the traditional knowledge of Indigenous people. Now, I'm going to begin to wrap up because I think it's important to recognize that this is a battle and it is an uphill battle. I said we've been doing this negotiation for 20-odd years and it is ongoing. But one of the challenges is that intellectual property is built, as we know it, is built very much on extractive labor. That is not the way Indigenous peoples live. It is also built on the extraction of natural resources. Indigenous people today are the primary stewards of our biodiversity. They are the primary stewards of any hope that we have of turning our climate crisis around. IP rights also tend to be extractive of culture. How many people in this room have watched Frozen? How many people have watched Frozen? All right. How many people have watched Lion King? All right. So most of you are probably unaware that Frozen was a retelling of an indigenous story by the Sami in Finland. And in fact, that movie became so problematic that Disney ultimately had to make some changes in order to honor the traditional knowledge of the Sami. Lion King, very similar story. None of these communities received a dime from the royalties that Disney accumulated as a result of these stories. The formalization and globalization of intellectual property has instated as a global system principles of protection that make innovation by the global South the public domain or the commons, and makes the only things subject to property rights the things that are consistent with an extractive culture, an extractive labor force, and extractive natural resources. So ultimately, what we have now is the demand by Indigenous people to be a part of the process. Indigenous people, with the conclusion and the completion of the United Nations Declaration on the Rights of Indigenous People, are now routinely present at the World Intellectual Property Organization negotiations. Is it changing the law? Not so much, but it is changing the process. And it is bringing new actors, new voices, and new types of innovation to compete at the global table with the intellectual property system that we know and have loved and have benefited from, certainly as America, for over these many centuries. In conclusion, let me say three things that are problematic about this system. In 2013, we saw the first victory of new actors. The Marrakesh Treaty, which created a mandatory exception for people with visual disabilities to have access to copyrighted works. I don't know if there are any visually impaired students at PACE. I have taught one blind law student in my entire career, and I can tell you how heartbreaking it was, the length of time it took to convert legal texts into texts that he could read. For the first time in its history, the Marrakesh Treaty created mandatory exceptions to make sure that visually impaired persons had the right to take copyrighted works and make them accessible to blind people. Stevie Wonder came out the night we concluded the treaty negotiations. It was just an incredible thing. And then just a few months ago, in 2024, Indigenous people, for the first time, were able to have their voice recognized in an intellectual property treaty. The WIPO Genetic Resources Treaty now requires that any patent application that is built on a genetic or that claims a genetic resource and associated traditional knowledge must disclose the source of that knowledge. We're beginning to see extra chairs at this IP table, and it is the first time that we are seeing human rights, indigenous rights, and intellectual property rights come together in a global ecosystem that is now beginning to ask the kinds of questions about what progress really means when other voices and other actors are invited to the intellectual property table. Thank you so much.